Hi everybody, it's very late at night and I'm still up. I was trying to watch a movie, but then I decided to do something progressive. As progressive as 1 a.m. will allow, and post a video on conditional acceptances in the regard of red light or traffic cameras. Um, right now, there's a plague going on where people are being sent tickets in the mail for at least $100 for speeding in areas throughout Chicagoland and now in Lake County. This is not going to go anywhere. There are ordinances in place that you can go to municipal code and look up. If you do a search for red light or traffic cameras, they will give you specifications as to maintenance, where they can be placed, signage that has to be visible to all drivers at all times in regard to if you are approaching an intersection or area that is being monitored by said equipment. So I'm posting this because I've had a lot of people express their discontent about receiving these things in the mail. I've received them as well. I do not speed where it's marked, especially where it's marked on, normal streets and highways. The interstate is one of those places that should have a little bit more flexibility, because if you have to move or pass someone, of course you have to accelerate to get beyond another vehicle that is also in motion at a certain rate. But on the street, they are very stringent because it's a money-making tool for municipalities right now. And when I mean municipalities, I mean the legal corporation of a city, village, township, or anything of the like within a legally incorporated state. I know I said a lot there, but it's pretty easy to follow. So when you receive these things in the mail, you do not have to fret. You need to complete what is called, under the Uniform Commercial Code, a conditional acceptance. When you conditionally accept something, or when there's a condition in mathematics per se, it's saying that if this is a circumstance or if this is a condition, then and only then will this be the outcome. So that is what you are officially declaring, legally declaring, when you send in a conditional acceptance. You are saying, if this is the case, if you can prove this is the case, then I will accept the things you say and the charges that accompany your claim. I will read off what I have done myself, conditional acceptances. So I won't even get into, oh gosh, this is the wrong one. 1 second. Let's see. I'll just pull it up. 1 moment. I'm not normally this off, but it's all good. So, in your conditional acceptance, no matter what, you are going to basically, it might look a little backward, you're going to head it off with a notice of dispute. It's going to say notice of dispute or conditional, nope, sorry, scratch that, hold on. It's going to say conditional acceptance, but let me open up this document because I'm all over the place and I apologize. Open. And the only reason why I don't want to stop the video now, because I know I kind of goof trooped a little bit, is because I explained a lot of things, and I don't want anyone to not be able to hear that information about where to look up certain things like codes and whatever. So here it is. I'm going to open it up. It says, basically at the top, it is a conditional notice of acceptance. Constructive notice of conditional acceptance. There we go. And it's opening up now. And I don't want this video to take forever and a day, and I'm sorry. But yes, at the top in the header, in all caps, it says constructive notice of conditional acceptance. The next line thereafter is going to read your name and your address the way it is presented on the ticket. Then a line that says certified mail number with a line for you to write that in on. The next line is going to say non pro tunc 2. That means in Latin, you should receive this by this date. So it's almost like when people would write a date in the future on their checks or something like that. It's basically saying the same thing. By this date, you should have it. The next line is going to be for your recipient. So if it's the city of Zion, if it's the city of Chicago, or whatever township, who cares, Newcastle, whatever, you're going to put that, their address, that is listed on the ticket that you would have to mail back. Then your subject is going to read your automated speed enforcement violation notice dated blah blah blah. That is important because you are specifically identifying what ticket and what date, what type of notice you received from them. So then after that, I typed in, I have received your notice dated on or about such and such date, to which I am returning and enclosing to you, and then in parentheses, all caps, automated speed enforcement violation, whatever the number, close parenthesis, and to which I am conditionally accepting all payment offers in the notice upon proof of claim that, 1, the city of whatever provide the claim in the form of a ticket, affidavit, or citation signed by an officer of whatever police department, state police, or sheriff whose duty it is to enforce traffic laws within the state of wherever you're at. Second, it says that the city of whatever provides certified documents of proper calibration, operation, and maintenance of the traffic cameras listed at the position of blah, blah, blah on the date of the alleged violation. Now, the reason I put that in the conditional acceptance is because when you demand this information by law, it has to be provided. You can also do a Freedom of Information application for these things, and they have to approve it or deny it within 30 days. And then even with the denial, there has to be an explanation. If someone or a municipality that is accusing you of doing something illegal or against an ordinance, if they don't provide certain things to you after you request it, after they've accused you of something, it furthers your case, basically. Number 3 says a video or motion picture of the city of whatever's claimed violation be made available to the respondent. That would be you or me, because we're responding to a ticket. Be made available for reviewing and examination as a motion picture provided on whatever the website that they tell you to go to does not provide evidence for either the city of whatever or whatever your name is, the respondent. Lastly, you're going to put that you have 10 days of receipt of the conditional acceptance to respond on a point-on-point basis, point-by-point basis, via sworn affidavit under your commercial liability, signing under penalty of perjury that facts contained therein are true, correct, complete, and not misleading. Mere declarations are insufficient. If an extension of time is needed to properly answer, please request it in writing, forwarding to whatever your address. Failure to respond will be deemed in agreement with the facts stated in the attached affidavit, and inability to prove your claim, hence granted dismissal. This answer constitutes notice to the recipient. And I'm sorry that I'm talking crazy because it's late. I got sinus stuff going on and it's late. Now, there is a little bit more stuff that's on this letter, and I would be more than happy to provide a template to people because I really don't want anyone to be victimized. The next part is going to be an affidavit of specific negative averment. It means it's basically a legal notice saying that you completely disagree with what they're trying to say. So the first line will say, the undersigned affiant, whatever your name, hereinafter. Affiant, so you are now giving a definition, saying that you're not going to refer to yourself as your name or your straw man name. You are going to say affiant. So affiant does solemnly swear, declare, and state as follows. Number 1, affiant is competent to state matters set forth therein. 2, affiant has knowledge of facts stated therein. 3, all facts herein are true, correct, complete, admissible as evidence, and if called upon as a witness, affiant will testify to their veracity. Then comes the next part, plain statement of facts. So the plain statement of facts is going to say, affiant says this. Affiant says, for instance, number 1, I need a ticket signed by an officer. A ticket coming from Arizona, Scottsdale, Arizona is not a legal document. It is merely an invoice or a bill, not a ticket. Okay? Then it says, number 2, you have not presented anything that incriminates me or proves your case. But it says it in these terms. Affiant sees no verifiable sworn evidence, etc., etc., etc. Last line will say, in witness thereof, I hereunto set my hand and seal on this day, whatever it is, month, and year, and hereby certify all statements made above are true, correct, and complete. You will date and sign this in front of a notary. You should not ever give any paperwork to a judicial, legislative, executive, marshal, branch of service, or whatever you want to call it, enforcement, without an official legal seal or a notarized seal on it, because at that point it becomes a legal contract, not just a document. And there will, it just looks better if you have to pursue it in court, and there's no ambiguity with it. So there's a lot to this. It takes time. I will say it does not work every time. You may have to go to court to fight this, but at least you don't accept it off the first go. Never, because that's accepting. That's just like accepting a plea when they have no evidence that you did anything wrong. You don't just, okay, well, I just want it off my back, so I'm going to accept this plea. That's how they get convictions up. That's how they continue to put us in the meat grinder. The other thing you are going to do with your conditional acceptance and your affidavit, you are going to return the ticket, the original ticket, to them. Make a copy, that's fine, for your records, but do not check off that you want a hearing by mail, that you want a hearing in person, nothing. If anything, you will write on the ticket, I do, or I have attached a conditional acceptance and affidavit. Please see those attachments. I do not want a hearing. Then on the back of the ticket, at the top left, you are going to sign. That is your way of saying, under the Uniform Commercial Code, that I am sending you your notice back because I have obviously a disagreement with it. And the papers attached are the specifications of my disagreement with the legal notice. Okay? You send everything certified as well. Send everything certified. Because why? The United States Postal Service is still an umbrella of government. There's no better way to certify that someone or entity has been given notice than by certifying your mailing, point blank period. So before you send it off, you want to put that certified mailing number on the line that I informed you about underneath your name and the city and all this other stuff, saying certified mail number blah blah blah. Now, I have a letter here that basically says, and I won't say where it's from, says notice of findings decision. To me, findings decision. This matter has been addressed at an administrative hearing. Due notice having been given and the administrative hearing officer being full advised, it is decided as follows. Violation number blah blah blah, violation of ordinance number blah blah blah, ordinance description, disobeying traffic control signal, offense location, date and time, blah blah blah. State plate, it has my plate number, my type of car, the model, finding and judgment, not liable, fine amount, $0.00, administrative officer, whatever that person's name is, and then the date. So that is the result of me giving a conditional acceptance to whatever municipality that said I disobeyed their violation with their speed camera or their red light camera. Again, it may not work every time. If it does not work, you will have either 30 days or 35 days, depending on the place where you got the ticket from, to file an administrative review, which is not really fun. But it's basically appealing a decision by an administrative law judge, which is basically a lawyer that is not a sitting judge, but a lawyer that, attorney that has been hired to mitigate and sort of adjudicate for the city to find people guilty or innocent. If you don't agree with the findings, you will have 30 days or 35 days to counter that with an administrative review in that circuit court for where those tickets derived. And that is something I will have to get into another time because it is not a cakewalk. But again, I'm posting this because I want people to be informed of their right. You have a constitutional right to counter any legal claim made against you, whether it is a debt, whether it is a violation of an ordinance, whether it is a criminal case, civil case, probate, whatever. We all need to know our rights and we all need to enforce our rights. I will kindly share a template of what I have to anybody that is serious about using it and doing it correctly. It must be done correctly because one rotten apple will spoil it for the bunch. If you are not careful and you do not completely fill out this information and use the legalese that is being provided to you, it will be, you'll be laughed at, and then you'll be sent something saying, oh, well, now you owe us double your fine because we found you guilty and you are late. That will happen if you do not do it correctly. So with that said, I end my turn, and if you want a copy, inbox me your email, and that's that. And I'm sorry for all the little bumps in the road in the beginning. It's really late. I'm kind of tired, but I had it on my mind to do it. And this, again, applies to anybody anywhere in the United States because we are all operating under the Uniform Commercial Code. And that's something I would ask everyone to look into for themselves. As long as we are operating in that, you have a certain right and duty to respond or to petition accordingly within those constraints. So it's been 21 minutes and 29 seconds and counting. That's enough of that. I'm going to take my behind to bed. Peace in the Middle East.